Assalamualaikum warahmatullahi wabarakatuh. My name is Wanu Shabika binti Wan Syazi. Today my group will present about the Multinational Corporation and human right violence case. Okay, first of all, the purpose for this case is to reflect the present legal position in regard to the upsagging human right violatory by the powerful multinational corporation in India that need to control. That's because India is the one area of law need to be released at international level by many stakeholders. For example, like company, register, judge, human right activity, and the student. Human right violence is corporate area is upsagging. It's happened because of lack of governance mechanism and vanity. Next is about progressive law are solved at the both international and national, which can maintain the balance between international and national and are ours to control such issue. Human right is a set fundamental right provided to every citizen and cannot be compromised. It organized sector even though highlighted gross violence by MNC. They are the first to stress the importance of a transparent, well-functioned, and just a legal system as a critical part of an enabling environment for investment and economic growth. They also argue that their responsibility is to make a profit and they do not have positive duty to obsess human rights. The change in the nature and location of power in globalized worlds that increase power had passed into hand of MNC. MNC can affect the economic welfare of the communities which they operate and due the indivisibility of human rights, so they have direct impact on the human right enjoyed by the community. Next, I will present about the position in India. First is instance of corporate human right abuse to legal business activity. For example, the slave trade or opinion trafficking by British East India Company and gas leak at Union Carbide chemical plant at the Bhopal. Next is ordinary law. It's like about fundamental right and the active principle of state policy. That remarkable because the location's constitution was drafted in the late 1940 when the nation of human rights was still fundamentally state-centric. Next is India Company Act of 1956 have provision about that could have criminally liable debts, liability crisis for branch of narrow corporate government issue. For example, provision do not cater to the situation the allegation are against violatory human rights. Next is Indian Penal Code is the possibility of company being held criminally liable for causing wrongs. For example, like section 305 of the Code Criminal Procedure 1973. Okay, next is tort law was a basic for suit against company for range of human right violation. It as primarily negligence and liability for employee wrongdoing. National Human Rights Legislative Commission not really dealing with corporate human right matter, but it was interfered in some branches and human right, like the case involving sexual harassment at the workplace, and it's also helped Son of Act in the Human Rights Act in 1993.
Today I will present about international scenario. A draft code of conduct was prepared by the Economic Social Council according responsibilities upon the TNCs in observing human rights norms. The same failed to be adopted due to major disagreements between the development and the developing countries. The preamble of the Universal Declaration of Human Rights call on every individual and every organ of society to promote and respect human rights. Every individual and every organ or society excluded, no one, no company, no market, no cyberspace, the UHDR applies to them all. OECD member states are required to establish national contact points (NCP), which has the primary responsibility to ensure the follow-up of the guidelines at the national level have even faced shortcomings with regard to effective implementation of OECD guidelines, since they do not consider OECD obligation as legally binding. The next point is the UN norms on the responsibilities of transnational corporations and other business enterprises with regard to human rights, adopted by the UN Subcommission on Human Rights in 2003, set out with some degree of specificity the human rights responsibilities of company. The UN Global Compact, which as of December 2005 has over 2,300 participating companies, recognizes that companies should respect international human rights standards. Its first two principles are: first, businesses should support and respect the protection of internationally proclaimed human rights. Second, make sure that they are not complicit in human rights abuses. International Council on Human Rights Policies 2002. The next part is critical analysis of the current scenario. First point is lack of laws and lax enforcement. On many occasions, court has to issue guidelines to fill in legislative gaps in matters. Even if the need for a new law is recognized, the process of enacting laws may take several years. The second point is absence of robust institutional mechanism. Courts in India at times provide a viable option to hold companies and their officials accountable for human rights violations. However, the efficacy and independence of courts is seriously undermined by two factors: corruption and huge backlogs of cases. The third point is corruption. All pervasive corruption has two direct implications. First, companies might be able to influence the course of justice through their economic power and political connections. Second, victims might lose confidence and incentive to use the legal system to seek redress for violence of their human rights. Fourth point is delay in judicial process. Judicial delays will continue to operate as obstacles in victims' quest to hold companies accountable for human rights violations, especially when companies employ delay as a defense. Poor victims are particularly likely to suffer from this delay. Fifth point is ignorance of one's right and indifference to right of others. Low levels of literacy and extensive poverty together pose serious challenges to the realization of human rights against powerful MNCs. The sixth point is expensive litigation, limited legal aid. In addition to court fees, victims would need considerable resources to hire competent lawyers so as to have any chance of success against a team of corporate lawyers. The availability of legal aid remains limited in practice. The seventh point is undeveloped tort law and class action to deal with mass torts. Although the Indian law allows class action, in practice this device has hardly been used in tort litigation. The Bhopal gas leakage presented a very good opportunity to invoke class action in a mass tort case. but the Indian government ended up acting as parents patriae and enacting a special law to cover all the victims. The 8th point is difficulties in criminal prosecution of companies. The Bhopal case demonstrates very clearly how difficult, time-consuming, and resource-intensive. First, it is not easy in practice to prove the required mens rea against senior officers of a company involved in the alleged criminal activity. Second, gaining access to internal corporate documents which might provide critical evidence is often not possible. Third, the task of criminal prosecution becomes more challenging if an overseas parent company is involved over which the court might not be able to secure effective jurisdiction. Fourth, extradition is never easy if there is an attempt to prosecute a corporate officer living in a foreign country, because governments of developing countries do not generally have the resources and the required political will go after big companies for fear of investment backlash. 9th point is difficulties in piercing the corporate veil. The limited applicability of piercing of corporate veil by the Indian courts causes a hardship to the victims of corporate human rights abuses, because on various occasions it becomes necessary for them to sue a parent company even though the actual violation might have resulted from the act of its subsidiaries.
Next, I will present about new development. This guideline will require company to write before government, respect for human rights, and also report on measurement that they have taken to support their accounts. This proposal effect form part of business responsibility guideline that will be prepared by Corporate Affairs Ministry. Company will have to put reason why they do not put the norm in the place of procedure which will guard against violation human rights. Company will have to explain reason behind their non-compliance, hence they're creating an indirect sanction. This detail will provide in their business responsibility statement accompanied by company annual report. Okay, next is current company law framework does not offer much hope for the victim, but two development indicate to provide change in the workplace. First, consistent with trend in many countries to introduce a mechanism which may different from in-company law to address the interests of non-shareholder stakeholder. The second one is issued by Indian Ministry of Corporate Affairs that provide in covering issues such as care for all stakeholders, ethical functioning, respect worker rights, and many more. These were made for clear the violent human rights through unethical behavior that they have learned from competitors using CSR framework. We proceed with conclusion. Now the company has accepted about the realization and protection of human rights. In India, there has already in a place that an extensive list of law that can be invoked by people to hold company accountable for human rights violation. Okay, first, the executive in several instances does not put force in a law that have been enacted by legislator. Second one is even if a law that published by executive, its enforcement often lacking in a view of inadequate manpower, underdevelopment, infrastructure, administrative concern, and corruption. Indian Companies Act 1956 does
anything to encourage company to socialize responsible or locate the interests of non-shareholder stakeholder. It's desirable to revise company law to bring consistent in international trend and detain the MNC to be watchful for human rights violation by showing that the corporation have human right obligation and responsibility to respect and to protect and to fulfill human rights. It's work in modest way to argue for better regulation for cooperation in relation in human rights.